Hello, everybody. Today's video is about a recent case that came out about the transfer of real estate. Always an interesting topic and interesting fact pattern. All I have to say is keep mama happy, right? This is the week that cases seem to come down where children are being disinherited by their parent, one sibling or the other. And it seems like the guys have gotten the bad end of the deal this week on my videos where both sons in both cases are the ones that got disinherited. So let me tell you about the facts and what happened and the deeds that were involved, because it's a very specific and very precise legal interpretation of the statutes dealing with deeds. And we do this all the time and we think that it's, no big deal, but let me tell you, it's a big deal when you lose out. So what happened was mom had a property and she deeded it to her two kids, and the deed is called a transfer on death deed. And a transfer on death deed is kind of like joint tenants, right of survivorship, that kind of a thing, but it's a future, so when mom dies, transfer on death to the two kids. And there's a statute that provides for it. We do these kind of deeds all the time. So mom does a TOD and on her property. And then a couple years later, something had happened. The son fell out of favor. And so mom quitclaim deeds the property to her daughter 100%. So the first deed is transfer on death to the two kids, gets recorded. Second deed, 2 years later, not recorded. Very key fact, right? So what happens when you've got a recorded deed on the one hand, and on the other hand, you've got an unrecorded deed, and then mom dies? So they're trying to figure out and balance these two statutes to say, well, transfer on death would normally vest the property in the two kids, but what do we do with this other one? So the court went through a very detailed look at the statute, and they started balancing these different sections, right? So I'm want to kind of get to it for you. And the statute has one provision, right, that says a transfer during the owner's lifetime terminates the beneficiary designation of that property. So that's one section. However, there's another section just right after that that says the owner can revoke that beneficiary designation if they record it or if they file a written undertaking, some type of written document. And since there was no specific revocation of that transfer on death deed, the statute seemed like it's in a conflict. Well, it is in conflict. So which one do you follow? The one that says you can just transfer, have that terminate automatically, or is it going to go this other way where you have to have a written recorded document? And what's the effect of that other deed, right? So then the court took another look at a different statute dealing with transfer on death conveyances. And that statute has the transfer subject to all conveyances, blah, 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 made during the owner's lifetime. So that contradicts in a third way the transfer on death statute. So you've got all these different conflicting decisions to make, and where's the court going to end up when you go back and forth, win, lose, win, lose, win, lose, right? So at the end of the day, the court holds, right, the holding is that basically the quitclaim deed was valid. And so even though it was not recorded, it was still valid. It's a very interesting principle. So don't be taking your quitclaim deeds lightly. They're valid even if they're unrecorded, particularly according to this case, right? So the deed was valid. There was an immediate transfer of all the property. Accordingly, there was no property left under that previous transfer on death deed that had been recorded. It's as if that property had all been disposed of by the later quitclaim deed, right? So at that point, right, there's nothing left. The daughter gets it all. The son gets nothing. And there's the end of the day. 3 different statutes, all with conflicting provisions. The Court of Appeals runs through it and gives you that analysis, very convoluted. set of findings, and I had fun reading it. I hope you enjoyed it as well. But again, bottom line, keep mama happy, because otherwise you're out of the will. You're going to be out of the will and out of the deed. So just another interesting case today. Be careful with your deeds. We draft them all the time. We'd be happy to help you. Have a great day. Thank you.